Ladies and gentlemen, in order to start the afternoon session, I would like to talk about the new things of the revised IP law on trademark and GI. So regarding the trademark, there are 10 points or 10 issues that you need to be aware of. Okay, so allow me to go to the specific points now. The first one is about the sound marks. So you know what, today on the market there is a sound mark that you can easily see in your enterprises as well. There are normal marks. It is the text marks and also the shape marks, right? So in the new regulation of the revised IP law 2022, one new mark has been added. It is a sound mark to comparable with CPTPP. So it's not only the visible marks, but also the non-visible marks. So the sound marks can be protected in the graphic format. So there are some other things related to sound marks that has been incorporated in the IP law. It is the first one. So in the article 73, it talks about the factors that are not protected. So that is the size containing the sounds.
Ok. Tôi xin nói phép.
Okay, I would like to repeat it. So regarding the regulations about sound marks, there are some regulations that you need to pay attention to. The first one, it is the factors, that we have to be aware of because the sound mark application can be refused. For example, it is related to the national anthem of the Socialist Republic of Vietnam or other countries. The second thing about the sound mark is it is considered non distinguishable. Sorry. So it is about when we talk about the sound mark application, right? So when you submit the application, and if it is a sound mark, you have to pay attention to Article 105. If the mark is sound mark, then it must be the audio file, and it must be expressed in the graphic format as well. So the Decree 65, which is just issued in 25th August recently, has some information about sound marks. So in Appendix number 1, you can read Appendix number 1. So first, in the template in the form, if it is sound mark, you have to put a tick in the box if the kind of mark that you register is sound mark, and also you need to have a detailed description of that kind of sound. What kind of musical instrument is it? Does it have a lyrics or not? Okay, so now talking about the marks, and it is also in appendix number 1 of decree. It must be digital, and the capacity is not exceed 3 megabytes, and it must be indicated in the music kind of with the file live, the music expression with the file lines, and so additional information about that.
Cũng có tại cái phần yêu.
And you can see this in the general requirements and also the detailed requirements. Second, it is about the 3D marks. Actually, the 3D marks is a kind of mark is a mark, but actually, this 3D mark was already put in the IP law 2005. So this is not new at all. But regarding the 3D mark protection, some people say it's still not clear, not specific yet. So there should have a more additional information to make it clearer. So the size, so the 3D marks, it is the um, if it doesn't show the nature, you can see an example about the 3D marks. Here's the ties of the cars. So when you can see the cracks, right? The slots on the tires. It shows this is not aesthetics factors, but it is the technical feature because the slots here, the slots on the tires, it creates the friction, right? So if it is kind of just a stripe or smooth, and then the tire just move and move and move, but no friction. But the slots on the tires can help the car move forward. So in case you register 3D, and it is the inherent characteristic of that product, it will not be protected under the 3D marks.
Năng phân biệt của nhãn hiệu 3 chiều liên
So regarding the distinction or distinctive, then the things about the 3D marks, for example, it's considered non-distinctive, but if when it has the normal shape of the goods or part of the goods, or the normal shapes of the package or the containers, or point C, well, if the 3D Max, it just is the one who it's just the one to create the values of the product, and then it's not protected at all.
quan hệ với kiểu dáng công nghiệp.
Now, regarding the industrial design, when the 3D Max has some repeated characteristic, or it's not different from the protected 3Ds, when it was already protected before the time you submit the application for the 3D Max protection, then that 3D Max is considered non-distinctive and it will be refused. The third point is well-known trademarks. So the well-known or the famous trademark actually is not changed very much, but it is just changed in the way that it will become clearer. So talking about the meaning of the words, of the terms, so when we use, the users can know it widely across the country of Vietnam. So this is to ensure the consistency with Article 75. And the Article 75 has been amended to. However, this has caused the controversies and arguments. However, the examination of one famous mark is based on one or more than one of these criteria. So it can be 1, 2, 3, 4, 5 criteria, not the understanding of the past. So all of the ideas in Article 2075 has to be re-examined.
Làm rõ hơn trong cái lần sửa đổi này.
So one more thing, it is about the linkage the linkage mark. Actually, linkage mark is not one kind of mark, but it just reflects the legality of the register um, marks for one subject or one owner. So the things, the regulation about this kind of mark are still enforced, and it means it does not depend on this legality. So this time's revision has added, like in Article 74, added the things about the distinctiveness at point E. Now, the point number 5 is the disclosure of a trademark. So regarding the trademark application, it is a procedure for disclosing the application. But before disclosing the application for trademarks can be disclosed right after it is received. This is also the CPTPP and also the law on access to information. Next point, it is about the objection to the application for trademarks. So, like as mentioned in one of the presentations this morning, you have to pay attention to Article 112A, because any third parties can object to the grant of protection certificates. And then point number 7 is about the suspension of examination. I personally think this is quite important related to trademarks, not only for enterprises, but also the representing agent companies. So when during the period of submitting the application, trademark application, the first two cases may happen. The first case that you can be accepted for granting the protection certificates, but the second one is that one of the reason why your trademark is non-distinguishable, because there is one trademark of other owners, and your trademark is the same to the trademark of that applicant. So then this terms law or this amended law come up with one solution that it can be summarized. There are two steps. The first step is when you request IP Vietnam to suspend the application examination, and after that it comes, the request for kind of ending the valid, and it is in the Article 95 of the document.
mà có thể
The second reason that your trademark may be refused because it is non-distinguishable. It's not only for the control brand but also for the brand that has been abolished, like a dead trademark, the trademark that has died. Okay, so like in point H of the Article 74 before. So if your trademark is the same or similar to the trademark that has no more valid, and it is not more than 5 years from the invalidity, then your trademark is considered non-distinguishable, non-distinctive. So now the time is reduced from 5 years to 3 years, and the way to overcome this control kind of trademarks
tạm dừng quy trình thẩm
is that you can request IP Vietnam to stop the application examination and to kind of make it expire, the validity expire, because after 5 years it was not used at all. Now the transitional provision So regarding the transitional provision, it is applicable to the application for the marks recognition that like the trademark that was launched before 1st January 2023. And the second point regarding this one, it is to make the term, to clarify the term for verification. So actually at IP Vietnam, we still do this, but the law in the Article 74 make it clearer because the period for comparing is before lodging the application. So, okay, the point number 8 is about trademark conflicts with other subjects. So it has added some basis for whether or not the trademarks, your trademarks or trademarks of enterprise can be distinguishable when it is in text with crops and other things. So we have point O and point P here. So one of the marks, it's kind of repeat things, and it creates a confusion with crops protected in Vietnam. And if that name was registered on goods and had the same or duplication with so if the symbol is the same, similar, and like the name, the image, the things in a book, and that was known widely before the application day. So that kind of sign or symbols is also considered non-distinguishable. Now, the point number 9, it's about the refusal to grant the protection certificate. So there must be a legal basis to confirm that the trademarks were registered for bad faith. The last point regarding trademark is about the protection certificate. So regarding this, there are 5 main points that that enterprises need to pay attention to. So in Article 93, it added the term to add international trademarks like a Madrid. So we have to follow the protocol or the Madrid treaty regarding Vietnam. So the time to identify the validity, it is from the time that or from the 12 months since the organization appointed Vietnam, depends on which time is earlier. The second one, it is the end of protected or protection laws. So this one is also this one follows the EVFDA's provision. So the one who can use the trademarks, in fact, if they make the users misunderstand the nature, the quality, the GI of the goods and products, services, that may be one of the basis to put an end to the trademarks application. And also at the Article 95, they also clarify by the time to eliminate the validity, to put an end in the validity. So for the applicants, in case they do not pay the fees, then the suspension when it's counted in case they give up the trademarks for other cases, for the remaining cases, includes the rights holder do not exist anymore. They did not use it for 5 consecutive years. And another thing, like you can see on the screen, so the period of ending that certificate is calculated as 5 days. Now, the third point regarding the protection certificate, it is also about because they have added one provision as the basis. So it is based on the fact that the applicants register that with the relevant authority. Yeah, the point number 4 regarding the trademark, it is at the entire or partly content, and this is a very new issues and outstanding issues on where marks are added to ensure the balance and the benefits of the domestic applicants and to ensure the unity between the international trademarks and domestic trademarks. So previously, according to the circular in the law, at the Article 15 of the circular, in case there are no so now in the regulation of the law on 1.8 on 1.8, in case the protect the subjects can meet the protection requirements, IP Vietnam will come up with a decision and to determine the time for the people to follow, to paying the fee, any fees related, and also regulation. Or, so the transitional regulation is also applicable to the application which have not received the result. So like before the 1st January 2023, the last point regarding the trademark protection certificates. So it is regulated in the Decree 65 recently issued. So narrowing the scope of the protection and for the owner, the protection owner can minimize the scope. Narrow down. First, you understand like a reduce some goods and services or the groups of goods and services. And second point, it is about the trademark sample. You remove the trademark sample, the the small details, and also the factors that are not protected separately, and that has been recognized in the trademark registration. Okay, my second part is about GI, geographical indication. So there are five parts regarding the GI. First one, it is about the homosonym. So this is already talk about this one. So the homosonym GI has the pronunciation or the spelling, the same pronunciation and the same pronunciation and spelling. So for the GI submitted below, and it has the pronunciation and spelling which is the same to another GI, and it has been used for the products itself. Then, when we see these problems, how can we ensure that this synonym um, GI is protected. Um, it consider meeting the protection conditions. So this kind of thing, Samak, it must have a one condition. So what is it? Because it has to be used in practice, doesn't cause confusion for the user about the geographical origin, and it must ensure the fair the fair treatment. Yeah. So for the homonymous GI, um, it has been pointed in Article 106. So the applicants must have explanatory documents and to ensure the distinction between the GI which existed before that. Now, the second point regarding GI overseas is that we have to clarify. So actually, this one is not new, but it has been there in the decree 2006. So the ones of overseas individuals and organizations overseas as the whole for the rights holders will have ability or will are entitled to that. So similarly, other things like objection to patent application, and so when you submit a GI application, you have to pay attention to deadlines. So 3 months, 3 months to it will be expressed within 3 months since the GI application was published.
Vấn đề pháp lý thứ tư.
Number four, so to ensure the relevance with EVFTA and practice, so the contents written on the protection certificate, so they doesn't need to record the individuals and organization which have that GI anymore. So specifically, so this is it. Some has been added. So besides clarifying the GIs overseas, eliminate the kind of ending the protection certificates in this relation has been added in Article 97. So when GI overseas is not effective in the country of origin anymore. And also the revised IP law 2022 has added like in Article 97 for GI, it has added the person who is entitled to request the additional, it is the individuals and organization according to Article 88 of the IP law, and all the ideas, the content may include the GI management company. Now, the last point is that um, government's regulations, and after that there will be basis for guidance. Other decrees to clarify the state management roles and also the assets ownership that has been specified in Decree 65 2003, especially in the Article 38 clarify things regarding GI. So the GI management agency must be responsible for developing the norms, and they have to manage it in the mechanism that they issues. And also another thing is in Article 38, So that has to meet all of the regulation at the Article 38. So it must have a products with a GI. What is GI? The methods, the procedure for people who use the GI, and the mechanism for examining, controlling the GI, and also responsibilities and yeah, the rights and of responsibilities. So this is everything's about GI. The GI must have. Yeah, the Article 123, 123 has been amended. So abolishing the ideas about allowing other people to use clause 2 of Article 123. So about is my presentation about marks and GIs. I hope that my presentation is useful to enterprises when you apply. Yes, submit your application regarding marks and GI.
First of all, I would like to express our sincere thanks to the IP Key Project for facilitating me opportunity to brief you of the new points of the IP laws as assigned by the organizers. I would like to review a theme on the protection of IP rights, the new points in the IP law, and also some guidance to implement specified in Decree number 65 as 2023, which took effect on the 23rd of August this year. So I'm very fortunate that this morning this Tung from the Copyright Office of Vietnam spoke a lot related to the protection of rights, copyrights and related rights, especially the two brand new points, 198A, 198B. So I not repeat what Mr. Tung has said this morning. I focus on the points related to the industrial ownership as well as the IP law. And I would like to start with my presentation now. Without further ado, there will be two main points. First of all, the regulation on the protection of rights, and also those related to the examination on IP. Upon with the request, I will speak a little bit slower for the interpreters can follow. So first of all, Article 198, there are some revisions and additions which are quite outstanding, quite salient, related to the application of the technical method to prevent infringement, including the application of solutions for the protection of the rights and application of the solutions to provide information and other technological solutions. So on the two first bullet points, protection of rights and providing information of the management of the rights, for very important, and also we attach importance to the application of other technological measures at the third bullet points, and in close to Article 88, mentioning the application of other technological measures. For example, providing the information of the right holders, the owner of the patents, or providing the information on the owner. So that is very vital in the current context of the cyberspace. And also in Article 198, the owner, the right holders, can request the infringer to remove the contents of infringement on the telecom environment on the internet. We see that now we see the booming of e-commerce in Vietnam. The e-commerce has been quite salient. For example, my family, my wife now, she mostly engaged in buying and selling online. She purchases things online. So the legal regulation should be in line with the reality, right? So in the recent revisions, Vietnam added the stipulations on removal of contents, which is quite in line with the current situation. And also in Article 198 on the self-protection of the owner, the holders of rights. Yeah, so the right holders can authorize other individuals or organizations to apply the measures. Many of you come from the right holder, so you know that right holder cannot have the time to conduct the supervision, monitoring, surveillance of the market all the time. No, so that he or she can protect their no rights. No, he or she can hire lawyers, counsels, law firms to do that for him or her. So Article 198 stipulated on this, so to facilitate them. And next, to remove the remove the law, remove the stipulation that. Organization, individuals who are suffering from losses or might be suffering from losses caused by unfair competition have the right to require the state management to apply the administrative measures in line with the law on competition. So such phrases apply the measure in line with the law on competition is removed, is erased because now we follow the IP law. Uh, and we also added one more entity which can be handled with their evaluation. That is, you can see on the screen, pháp nhân thương mại, which is a trade legal entity. Yeah, they are added. In the past, they say individuals. And also related to the criminal prosecution, we know that there is the concept of counterfeit goods. So there is a revision in Article 213. First, to separate the two types of things, uh, um, label and trademarks with signs of overlapping or similar. So and also well, the article number 213 defined the communities of the fake of the counterfeit GIs. So for the the labeling of the GI is conducted by the organizations or individuals uh, who the communities with the fake GIs are the GIs or packages of GIs with the signal, the sign or label or marks with the proper with the marks or trademarks which can be confusing and also in 214 it also referred that the organization and individuals which have been infringing shall be applied with the sanctions, penalties, and other remedying activities in line with the law on administrative reform. So, for the new version, it refers to the legislation on administrative violations so that they can rely on the law on administrative violation to deal with such infringement. Article 214 also stipulated on the removal, the lifting of the forms of administrative penalties because, as I said earlier, those have been specified in the law on administrative violations already. And here, the changes in article number 214. Yeah. And with the same reason that it has been stipulated in the law on administrative violations handling, which leads to the cancellation, the removal of article number 215. And one more point which has also been changed quite fundamentally uh, on the IP protection, that is the measure of control import-export communities related to IP in article number 216. Temporary cessation of fulfilling the customs of procedures for the communities which are suspected of infringing IP rights. So if the custom office have the doubts or suspicions that this one is the infringement, they can perform the temporary cessation of custom procedures. So it is in line with EVFTA and also Vietnam's regulations. And point 4 also is added, saying that custom office what kind of procedures the custom office needs to do. The custom office will have to notify to the right holders, and within 10 working days since the notification day, if the right holder does not bring the lawsuit and the custom office does not decided to handle the cases in line with the administrative legislation, the custom office shall have to continue with the custom procedures clearance for that commodity. And from that, accordingly, in article point 2, article number 73, um, on the temporary cessation of customs procedures, when the custom office suspect that it is the um, illegal goods in terms of the intellectual property protection, on the authority procedures and order, so that the custom office can temporarily cease cessation, conduct the temporary cessation for the procedures of customs. You can see here some articles speak about that. Article number 99 on the right to require the control of import-export goods. Article number 100 on the competency authority to receive the dossier 101 and so. So the second part, which is also very closely closely linked to the protection of IP rights, that is the examination of the intellectual property. Some of these stipulations have been moved from Chapter 6 of Decree 105 to the revised IP law. First, to define the two systems of examination. First, the judicial examination, which is conducted in line with the legal regulation on judicial examination. And the principles of conducting examination in paragraph number 4, section number 4, one more principle is added. The examination course are defined in agreement between the one who requests for the examination and the individuals or organization performing the examinations. So the examination cost is defined based on agreement, consent between the two sides. And some regulations on the conditions have been removed, lifted. For example, the requirements of having human resources, technical facilities, meeting the requirements of the examination activities in the law, or they have to have the function of conducting examination activities on intellectual properties, and also removed have been the regulations on those who are eligible to file the request for examination. Yeah, so you can see such information and also others, and also information on the examination of IP law in degree number 65, article number 105 on the forms of operations of forms activities of examination 106, right obligations of the examiner 107, right obligations of the examining organization 108, checking the examination activities 109, and 110 on the providing, reproviding, and revocation of licenses on examination. So it has been the new points in the new IP legislation of Vietnam in the revised IP law 2022, as well as the just released decree number 65 of 2023. So we would like to conclude the presentation here. Thank you. So you all can raise your questions. Yeah, the floor is open to you all. I think there will be many points on things like trademark, examination, and so on. So the floor is open to all of you. Maybe you can stand up so that it will be not sleepy. So in relation to the revised IP law, I have a question and also ask Mr. Bay to clarify further the implication of the policymakers, the law drafters, when speak about the distinctiveness of the brands, the trademarks. So that for the new law, there are two cases, absolute, like in 73.7, related to the signs that include the copy of the product. That it means the absolute elimination. And for the second one, resolute elimination, Article 74.2. 74.2p. Yeah, so similar that it can cause confusion. And the image is known widely before the submission date of the application. In fact, this is something quite new in the IP law. So when mentioning copyright, the conflicts arise between the trademarks and copyrights, and you include both things. One, the whole product, the whole artwork, and the other side only the image of the characters. So Mr. Bai, could you share with us a little bit what the drafters of the law were implying about when were working on those two articles? Thank you, Ms. Ming. I would like to ask any of you would like to comment on that or not among the audience? Any comments to what she has raised? Mr. Tung, yeah, I would like to invite you to join. So let's envision the artwork, the work to be protected. It includes literature, artistic, movies, cinematography, applied art, so many kind of works, right? Yeah, 14, right? 14 types of works, right? So maybe given the function and requirements of a trademark, Miss Ming, you and everyone can envision for me what kind of trademark can cover all of the kind of work. Can, if it includes the whole movie, can it be applied? If it includes the whole novel, can it be registered as a trademark? No. So it would be a very rare case. So we were speaking about typicalness, right? Yeah, this one. Yeah, this morning. So that is my response to the queries on article number 73, and a very famous image of Doraemon. Doraemon, anime cartoon character of Japan. Can it become like that, Mr. Tung? Microphone, please. The image of Doraemon, known by many people. is the cartoon of Japan, the machine cat, right? So if we take that, just give an example. Yeah, if we apply that into article number 74, it need to be somehow very famous. Not every image in a work can be used as a control example. So the difference here, you see article number 73, when we mention the absolute elimination, when it is taken, copied 100%, it cannot be protected, right? But here it is only one factor, one element of the work is protected if it has become renowned, well known. It does not mean that our rejection of the work means that we protect it like that. We cannot explain article number 74 in direction that we protect. We cannot lead to the thinking that that single image is protected. Okay, I will rephrase to be more understandable. In article number 74.2, I do not remember precisely. If someone register for a trademark which is the same or identical or similar to another trademark of the other which has had been widely used, he will be rejected that. But if that image which has been but is that product which has been proper widely used, is it protected? So that product is widely used, but it has not been registered. So can you ask the state management agency or the regulator, like the court handle the case another person who register for such a trademark? Can you do that? No, no, you cannot. Right? That is a right to prevent others to register, but is that does not mean that that image belongs to the right. So that I would like to explain further to you. Mm. With my specific example. So uh, why they put that into this situation? Yeah, you can discuss further. You can debate. Yeah. I although maybe I have understood partially the implication of the draft from what you said. Do you think that it is not?
Okay, so if you think it's not reasonable, please let me know what is not reasonable. Because I feel that here the copyright protection is absolute. Like Article 73 is about the absolute thing. Like you said, no one can put the whole work to put in a mark, in a framework of a mark, trademark, except for the applied artwork. But absolute protection in Article 74, Article like widely known. So here the applied artwork, it's like most of that has been created. Like you created it several days ago before the submission day. It is still considered the. I'm sorry, I'm speaking quite fast. I'm sorry. Okay, I mean that the Article 73, the absolute protection scope is too broad, right? But in the aspect of the Article 74, it is known widely. So then the decrees or circulars, does it put into consideration? Okay, I'll keep going. Yeah, for the copy, yeah, because why the rights of the examiners, when they examine the trademark or the mark. Okay, I get your point. However, In this situation, there's no guidance, no, more specific guidance. I think so. There will be no more specific guidance. But I want you to talk more about the Article 73, with the copy of the artwork, like apply artwork. You cannot bring the very big artwork, to the registration. Anyway, when it was already protected at the time of creation, like I submitted the application, and then 2 or 3 days before that, people already created that, because no need for any registration. So in that case, is it considered infringement or violation? No, I don't think this is related to violations. So we should explain about it in this way. Other people from IP Vietnam, please help me to add any more information to make it clearer. So from a trademark, that we use to distinguish it with services. So like when a person, let's talk about the applied artwork, okay? Because other kind of work is meaningless in the not applicable in the Article 73. So in this case, if we use that site for registration, registering our trademark, that this is similar to the size, related to personal identity in Article 22. So like a lot of things in Article 23 are related to the individuals and organizations as rights holders. So I think that's the way, that's the place, that's the way we should. And Martin, if you have any information to add, welcome. But I think that's the best direction. That's the best way to explain about this. So Mr. Duc, or you wanna? Okay, so I think from our understanding, that's the best answer we can provide. Let me add some more points. So in your situation, you mentioned that you registered today, but 2 days before that, someone created a very similar, the same artwork, apply artwork. So from right from the time of creating that artwork, it has been already protected. So without this one, and the trademark was issued, and they use their own of kind of goods, and circulated it in the market, and then the rights, is that protected? She should speak to the mic. She's not speaking to the mic. I cannot hear. Interpreter cannot hear her. Okay, I confirm that examiners do not actively examine that article, but it will be provided by the third party. But I want to add one more point. Ms. Ming, you talk about the Article 73. It's all the work, and we do not need to prove anything. But Article 74 say famous and etc. So the subjects in Article 74, like a character in one artwork itself, it's not a subject. But so a character in an artwork is not enough as a subject of any intellectual property, right? Yes, and also I would like to add some more points. Article 73 about the copyright. It is an additional, totally newly added article. But before, in something like Circular 04 mentioned something about that already. So there's possibility creating the confusion about the origin because of the copyright holder. So we also have to examine the confusion factors as well, because you did it. But here in the Article 73 didn't talk about the confusion, talk about the widely or broad scope, and it's not the owners themselves. Oh, Miss Ming, you're talking about the 74.2 P, right? Here, it's still talking about the confusion. Now, let me read it. The size of duplication and confusion. That no, I understand. Okay, the duplication or confusion. But here, So in the 39.12 of the circular 01, so between the law and circular there is inconsistency. No, I'm talking about the ideas when we transfer that ideas from the circular to the law. Is it reasonable? Because in the circular, sorry, in the circular existing circulars, that the factors they say that the factors in duplications which copyright makes the user confused. So look at that phrase, and it's very confusing phrase. Okay, let me read the whole thing. Now, the size of duplication or similarity that leads to confusions. The characters in a work known in a widely before the submission date, except for the permission of the owners of that work. So the ticket of the others and sorry. Okay. So with this, what was the difference in terms of the implication compared with the circular mentioned by Ms. Ming before? Because in the Article 74, finally, the confusion. So what is the final objective? What's that? What's the final aim of that? So finally, it is confusion, the relationship with the owners of the artwork. Because actually, this is about the law enforcement when it is practiced or implemented, or in practice, the trademark is issued. How to approve the copyright violation. So the similar or duplicated trademark, it depends on the examiner's criteria. But the confusions of the users in practice when they consume goods, no. Because in Article 74 now, any, whether or not there is a woods users, the examiners, the confusions always comes from the user where regardless, normally the confusion comes from the user. Examiners are not confused, but the users are confused, not the examiners. So I think whether or not the users in any sentences here, the confusions always come from the users, because representative or the owners of the true trademarks are never confused, but the confusion comes from the users. The users are confused.
Say that the confusion in trademark has absolutely nothing to do with copyright. Zero, nothing. Copyright is copying. It comes from copying. You do not make something similar, you copy and paste. That's copyright. And it's copied. So there is no, when something is copied, you don't need an examiner, you don't need a person. A copy is a copy. A machine can recognize a copy. That's copyright. Trademark is completely different. Trademark is a right which has been registered. It belongs to an owner. Then it goes to the market and it is confronted to the buyers. The buyers have nothing to do with the owner of the trademark. The buyers are not copying anything. The buyers are only maybe confused about the origin of the product. And that's where the only confusion comes in. The confusion, as we explained, is on the buyer, not anybody who no. When I buy a perfume, I have no intention to produce a perfume. I do not want to copy the perfume. I want to use it, and I may be confused about the origin. So that's the only confusion. But copyright and trademark rights copyright has nothing to do with confusion. It's only on the level of the buyer. Thank you. But you already explained this much better than me.
Thank you. Thì ông đã giải thích như vậy mọi người hai ý, tức là bản thân nhãn hiệu với lại cái bản thân cái việc xâm phạm.
Sorry. So yes, Martin has already provided some additional information. So I hope that everybody is clear now. So Miss Ming talking about sentence in a circulars, right? But I think the sentence may be confusing, and the owner of that trademark has relationship with the copyright holder, right? So in this case, I would like to re-explain about it. So between the two things, there are two difference. So what is copyright violation? Copy for use or copy for sale for selling as copyrights. But the objective of the Article 24, it is not a work, so no copy of any work there. This is protecting, as I understand, protecting does not only to protect the owner, the copyright owner, the copyright holder. Is that right? But it's protecting the consumers. So imagine that in many laws, like even Article 74 or 73, it is going in that direction. So I would say, for example, in Article 74.2 something, if I remember correctly, it's about a name of a crop, okay, a crop variety. So yeah, so I would like to say to make it clearer about this one, about the copyright, because in the law, amended law, there is one of the things that we have to clarify. So if one size which is similar or duplicated with the name of a crop variety, it will not cannot be registered as a trademark, and that has nothing to do with kind of increasing the rights for the crop variety owner, but the ordinance on crop variety. When you submit an application, you have to name the crop ST25 or the flower 9 or flower 10. So it will be called forever, many years, even though it is only protected for 20 years. So whenever later that variety of rice is used, it is called ST25. So to avoid confusion for consumers. So please don't put it in the things that always protect the person who owns that, okay? So the P is different from the O, the crop varieties. Okay, I understand. Okay, I want to say like the O that we have to ask for permission. It's okay, but the other thing is always not okay. It's not kind of allowable, but I just want to say like so we also have to put it because the Article 73 and Article 74, it seems like the law is amended in the ways that make it absolute or kind of put too much effort, too much significance on the protection. So I just want to explain it in that way. Yeah. So okay, another person. Okay, another person. Okay, I'd like to introduce that. I'm Associate Professor Dr. Nguyen from the Law University under Viet Nam Law National University. So from the morning up to now, most of the question focus on copyright and also the things that were interest of the enterprises. But I come from the academia because the name of our workshop today is a copyright to promote the innovation and creativity. And I have read all of the presentation this morning up to now, but I don't see anything about innovations and creativity, because you say about the promotion of innovation and creativity. So these changes are based on what criteria to promote to increase innovation and creativity. Now let me repeat my question. So the amendments, revision to encourage innovations. So based on what, and based on what criteria? Okay, thank you. The title of the workshop, the title of a law, or any titles of anything, right? So in many cases, because normally I see in an agreement or in a treaty, international treaty, there is one sentence. I think it's interesting. So the titles of this article, the title of the article doesn't imply covering everything it means in it. Okay. Anyway, let me respond to you now. So if we think about it in like this morning, in my opening remark, when I talk about the promote the social economic development and innovations, we have admitted that intellectual property is one tool to promote social economic development and innovation. And in order to make it work, we have to institutionalize it, right, or put it in the law. So the purpose of the workshop today is to provide you with the latest updates on that. But if we talk about the innovation, we can see like in Vietnam, when we change the revising the law, there are 7 policies, and one policy exclusively is about protection, changing the approach, the rights to register or defining the owners, copyright owners, from scientific technology, tax using the state budget. So the 7 policies, but one policy aims at that. And I know that people here coming from enterprises, you may not be aware of that, and you don't care about that because you mainly work on the patent of foreigners. Maybe you know the bottleneck of the US, right? About the patent law of the US, right? So changing, instead of investment, the state invest in it, but the state owns that. So now the own the kind of hosting agency like a university or research institutes will be under the name of the owners to explore to explore it. Not to mention that other changes like in more transparent in regulations, and somehow it contributes to the innovations of enterprises. So that is the overall approach. This is not the policy. It's like okay, allocate this amount of money to you of this agency for promoting innovation. So that's the approach. Yeah, that's what my response to the question. This is the kind of approach from legal perspective. So, Your Excellency, DDG, Bay, IP Vietnam, and also other people here. So I have some questions regarding the implementation of the IP law. Of course, we have a mechanism to protect the enterprises regarding trademarks once it has been, registered for protection. But in fact, there are still cases when the enterprises name the trademarks like some other enterprises, they may put it in the names of their products for their business registration. So the mechanism now only allows the enterprises to register to protect so by what? Yeah, so the inspectorates from the Ministry of Science and Technology and send it to the business registration to require that people to stop stop it, stop that infringement. But sometimes the processing time is it takes a lot of time, and the person who use that trademarks, that names, has already produced goods and has direct impacts on the original, enterprises. So what are the mechanisms for protecting the original enterprises, the primary enterprises, right? So, what do you think? Do we have any initiative? Yeah, personally, do you have any initiative? Do you have any ideas? Because now I think that now the business registration agency, when they receive the dossiers, the application, they will issue. It means don't make it auto, so like what is 1 year. So it means you require them to review and to. So that's the logic. So I would like to give some recommendation. Once we have a detect that in reality, and there has been letters and requests sent to MOSD, Ministry of Science. Yes, your question is clear now. Do you need to, or you just want to ask that? Okay, thank you. I understand. So I will answer and later. Maybe Martin can have some comments on that, because yesterday or the day before yesterday we had a workshop, kind of technical workshop on implementation of EVFTA, including the mechanism for registering the non examination something. So here I would like to comment rather than responding to you. Is that okay? So there are two examples that I would like to talk now. First one is the procedure for business registration, and second, it is the customs, control of import export. Is not about intellectual property. Now, so when you talk about business registration, some provinces they try like 4 p.m. After 4 hours, then one registration will be the registration will be completed, and this is kind of amazing reform in administrative procedures, and enterprises make great applause. They clap their hands. They're so happy for that because of the administrative reform, right? So good, but nothing is kind of cheap, but good quality, right? And same to the custom clearance procedure. Now the custom clearance procedure are quite simple, right? It has been kind of simplified, but everything has two sides, okay? Pros and cons. So like we said before, yeah, okay. If the registration business registration agency, okay, so also get a pre-check. So instead of okay, the name of the enterprise cannot be like this, cannot be like that. If it's like this, if like that, they have to follow this procedure or that procedure, the procedure like you said before, right? So that we have to invite the sorry, intellectual property, and not to mention that the name of businesses are duplicated with a trademark, right? Sure, if you look at that, you look at the tangible products, the visible products, that you can see that many times you don't know a company has the name duplicating the the name of the product, because in from the user you never pay attention to the name of the company, of the producers of the water, right? But so here I just want to have that provide that comment, because there is always two sides. I don't mean kind of to argue for the slowness or the lateness or delays in our processing the request, but there is a representative from EU delegation here. So in order to do that, we need a lot of conditions, meet a lot of the conditions, and in fact, or reverse, it's easy here, but it's difficult there, right? So yeah, so I just want to have some comments, like so maybe Martin may want to say something. Okay, Martin, please go ahead. Tôi nghĩ là câu hỏi của chị ấy sẽ liên quan đến cái việc là
You file for registration and it is registered. So what happens in the time while the office is working? So let's say you file for a trademark application, which you want to register a trademark application, and the office needs, for whatever reason, it needs 1 year because there was an opposition. And while the office is still working on your trademark registration, somebody else comes and he uses basically your trademark. So what happens with you? What happens with you is it's bad luck, because as long as your trademark is not registered, you are not protected. That's that simple. And the only thing what you can hope for is that your office is fast. And usually your office is fast. Normally when you file for a trademark, we are talking about a few months and the trademark is registered. For the trademarks, this is anyway not a problem because a trademark is a very long-lasting thing. A trademark can live forever, and normally when you have a trademark, when you create a trademark, you are not the first thing what you are doing. You are not running to register the trademark. This is not how trademarks work. Trademarks is different. Trademarks is you put a product on the market. On the trademark, you see it sells or it does not sell. Let's say it sells, the trademark becomes known, and then you have the idea, because it is a success, you register it. In this, at that time, you maybe have already used it for several years. Then finally you register it. And then the office needs 6 months to register the trademark. You file and then you register. It is very unlikely that after you have used your trademark such a long time, that now in this very moment somebody else comes and wants to register the same trademark. So you do not have really a problem in timing in trademarks. In patents, it's completely different. Patents is different because in patents, when you have created an invention and you put it on the market, then everything has to be really fast. In the moment you have created an invention, you have to be really fast. You have to run to the office, then you put your product on the market, and technical products are usually copied very fast. Then you have a problem, because as long as your office needs, as bigger is the damage. Later, when your patent is registered, you get from the court a compensation for the past, for the damage in the past. But that's a small thing. In patents, it's different. There, you really need to have the office working fast. But in trademarks, it's not an issue. So what we can only say to the offices, you do a good job in trademark registration. You are anyway already fast, and in patent, it is the problem is the backlog, and any time of filing and registering patents should be as fast as possible, because there indeed for the clients they have a problem when another person comes and copies.
Vâng, một câu hỏi cho ông Martin. Tôi muốn hỏi.
Martin, I have one question for you. Martin, one question for you. In Europe, in general, okay, because the period to handle an infringement, because in EU's you have a court, right? So how long does it take the court to handle because many people they complain about Vietnam. So I don't know if Vietnam is Martin. I know that you don't complain about Vietnam, but I want to see about as you know that you say you love Vietnam. So I want to see in Europe.
Before I started working in civil service, I was a litigator. I was working in private practice, and particularly specialized on litigation. And so I was litigating mostly about patents. And in Europe, you have two systems. You have a slow system, which gives you a full right, and you have a fast system. The fast system is you have what we call intermediate measures, the measures which are taken immediate effect. Let's say you have a patent, and you see a copying coming up on an international fair. You see, he has copied me. I didn't know he copied me. Then you can run to the court, and you literally run. You run to the court, and you want a preliminary injunction, and you get the preliminary injunctions the same day. The judge is sitting there. You prepare the papers, and you get a preliminary injunction. You can stop it immediately. So I have done this several times. You go with this paper, you go to the international fair, and you take, you stop the selling of the infringing goods, preliminary injunction, and then later you make a full court. If the preliminary injunction was wrong because it was not a copy or your patent was not valid, you pay the damage. So let's say when it was wrong that you stopped the other person, you pay the damage. Or it is confirmed and then it develops into full decision. So we have a quick system, intermediate injunction, and you have a more profound decision afterwards. But even the long one, as a full court proceeding, is around 1 year. So it takes around 1 year to have a full decision. It's particularly fast. It changes from country to country. In United States, it takes much longer, but in Germany, for instance, it's around 1 year and you have a decision.
Okay. Thank you, Matt. Đấy, ông cung cấp thông tin như vậy, nhưng mà chúng ta phải hình dung phiên.
Yeah, so like thanks Martin for that. So 3 steps like that. So first step is equivalent to our law. It's kind of temporary injunction, right? Interlocutory junction, right? And the 1 year, 1 year, it is about the final judgment, right? But I believe that the case is about the patent that maybe on theory it is 1 year like in our law as well, but it's quite long, right? Okay, thank you, Martin, very much. Next person. Yeah, I would like to have some more comments. In fact, only enterprises that has developed that will be targeted by other enterprises, and other enterprises may take advantage of their trademark for bad faith activities. Right now, we do not have an pre-check mechanism, like you said, but I would like to propose that in this case, when there is already the conclusion from Science and Technology Inspectorate, then so between MOSD and the business registration agency, there should be something like the trademark that has the checklist of the trademarks that has been violated, so that the business registration agency will have that checklist. So when they consider the application for issuing the registration, so they will know. But I think in fact it's not very many. So on the website of business registration portal, there is a link to IP Viet Nam. So like from our IP, I don't remember exactly, but they are the one who they work closely, and so in the modern approach, modern means delegates or like all the rights to the registering people. So I like that system. I like that system. So the enterprises, even though I have to pay because to get information. So I confirm that there is link, and IP Viet Nam and Business Registration Agency has created that link, but not for registering officers. Basically, the streamline was a simplified procedure like a interlocutory injunction. We can never put it in the law like okay, enterprises has to say have to check everything to prove that you are good in order to get the registration. We can never come up with something like that to confirm with you, because even the trademark registration, IP Viet Nam only examine the content instead of examining the format, right? So if you want if you want it to be done fast, so I want to reconfirm that the law on enterprises has been clear about the conditions and say exactly, responsibilities belong to whom. And if the problem happens, what are the ways to deal with that? Like we invite the judge, because it not mean that when there is duplication means violations, because they do business with everything, with all kinds of things. But the trademark owners maybe only have one or two groups of services and goods.
Trong khi đó quyền kinh doanh của doanh nghiệp là tự do.
But the business rights of enterprises, it is they have freedom to do that. So okay, so you are the clients of trademark owner and you suffer from that. But tomorrow you will experience a situation when a lot of clients requires hire you to register a business, and you say, oh my god, why the procedure is so long, what's problem, I'm here, my trademark is duplicated, but doesn't mean that I have violation. So today we are the lawyers of the claimants. Yeah, but yesterday you're maybe the lawyers of the defendants. Uh,
Hai là thủ tục về về đăng ký doanh nghiệp là tiếp cận theo hướng
yeah, so it's a post check, yeah, post check approach.
do và bản thân chính nhà nước, lãnh đạo các cơ quan nhà nước hay là dân chúng.
Yeah, so the people, the citizen themselves, okay.
Khi mà thủ tục hải quan rất đơn giản.
Yeah, so when the custom clearance, the custom clearance procedure now is very simple, has been simplified. So as however, there are some products that has been here still have a problem. So as buyers, do you feel upset about that? So in terms like post check, so they have to check everything. To make sure that it's okay before it is allowed to get into the market in Vietnam. So with even the post check, we cannot control. This is like a risk control mechanism, right? Okay, now other questions.
Xin chào các vị đại biểu, em tự giới thiệu, em tên là Hạnh đến từ đại diện Việt An ạ. Em có một cái câu hỏi về cái nội dung mà tạm dừng thẩm định đấy để vượt đối chứng ấy ạ. Thì em thấy ở đây thì có nêu về cái khi mà đơn đăng ký nhãn hiệu mà có lý do mà bị từ chối do tương tự gây nhầm lẫn thì mình có thể đề nghị tạm dừng thẩm định, sau đó thì để làm cái đề nghị chấm dứt hiệu lực đối với cái đối chứng. Thì em muốn hỏi là cái trong trường hợp mà cái đơn đăng ký nhãn hiệu của em bị từ chối thì lúc đấy em mới làm cái thủ tục đề nghị chấm dứt đối với cái nhãn hiệu mà
It's refused, and then yeah, to refuse the kind of control, and then in that case, so after the induction takes effect, then the time, how we calculate it, the time to continue it, or after. Sorry, the question is interesting.
thứ hai của em là liên quan đến vấn đề phản.
Yeah, so actually here there is a new point. The registration has not been accepted, and so I want to ask, right after it is accepted, received, it is counted from time, and where we can have information about that. And so 5 months after it is published or announced.
So, being publicity, it means that everyone can access. That is công khai, and công bố or declaration. It means a declaration. Yeah, to declare. And make available as in clause number 1. It means that if anyone has the demand, he or she can access. But the best way to access is that when we have a full IT system, everything would be on the screen and the public would be accessible to that. Yeah, that is our target, that is our aim. But now, when we have not been able to do that yet, to make it public for everyone to access, you can come to us at the IP office of Viet Nam, and you will be able to see that. You will be allowed to see that because you see there is still some debate. When can it be accessed? So in line with clause number 1, when the IP office has given the job, given the seal on that, anyone can access to us, come to us and see that. Now it is not available online for everyone yet, but we will try to do that. So far, when you want to know, you can come to us, so that you can avoid filing the duplicate application, and we aim to put those things on our electronic system soon. For the second point of a question, let's envision we are handling an application, then we intend to reject, to refuse. So you feedback to us. The law stipulates that we shall have to respond to the feedback within some period of time. And for the temporary cessation, for you to temporarily stop, it can be considered as your the feedback to your opinion, and then you can say your opinion again. But in reality, you know that so sometimes we are facing overload. There's so many applications. But yeah, we find the question quite logical. Yeah, legally topical. So one final question before the break. Ms. Ming has raised 2 questions already. So if someone would like to speak, I would like to prioritize her. And if there no one speak, I would let her speak again. So to ensure the equality, to ensure balance among the audience. Yeah, you can raise question, and who will answer, me or Mr. Đức or Mr. Tung, will depends on us, the scope of the question. I like also to ask about the temporary cessation. In Article 17 and 96, it said about the bad intention when launching the yeah, and the license, the certificate which has been provided can even be revoked, right? Okay, with a revocation. What about the lodging of the lesson in the past? Do not say about the in the past. So we can say now something like injunction in English. So let's say about the present. Yeah, not speak about the past anymore. Can if the examiner find that the application is something bad faith, he or she handle it, or will he or she give it to the court? Because I know that the bad faith might be lodged via the by means of objection letter. So for the trademark the trademark application that a third party want to object due to the bad faith, how will or she do? We need to read that again. 117.3C.
Ở đây tôi phải đọc lại cái chỗ này.
Yeah, I need to read this article myself. 117. The procedures related to step point C, clause 3. IP office will do like this. Temporary cessation of the procedures upon receipt the copy of the notification of the court on a lawsuit brought by a third party related to the industrial property rights, and based on the result of handling of the court, the IP office will continue with the handling. So your question is that given the bad faith in the petition, in the application, we need based on the objection of the third party, right? So you raise the question whether the examiner will handle on that or will do nothing, just referring to the court, just recommending them to refer to the court. Microphone, please, for the interpreter to interpret. Yeah, they have all of the evidence on the bad faith, so they think that they can be put into the court, and the IP office will work in line with the judgment of the court. Yeah, I also want to interpret like that. Yeah, this guy is an expert of bad faith. Yeah, yesterday we were listening on bad faith. So in Europe, bad faith is not used in handling of application. No, it is only used in the process of requesting for removal, cancellation, because that guy registered in bad faith, but to prove that, during the process of application, is it easy? Or the bad faith will revealed only after he has registered for example, I have registered the trademark of Mr. Hoang Anh, and then after registration is approved, we have a kind of offer. Yeah, I have registered this trademark. If you use, you have to pay me 100,000 Vietnamese dong. Otherwise, I will sue you to the court. Yeah, so in that case, the bad faith has been revealed. Otherwise, when a control right holder says that, oh, that guy is having bad faith, he is now applying to the IP office, and he is having a bad faith, but it is not quite easy to prove. So, for me, if I am the one who work on the application, I always work to adaptation that except for the case it is obviously bad faith with sufficient evidence. Only in that case would I decide on rejection. Otherwise, yeah, only in that case we will decide ourselves in the IP office. Otherwise, we will invite them to go to the court to handle whether it is bad faith or not. Thank you.